Hello everybody, and I'm lucky to be here today with Kiren Chitkara, who's a estate planning specialist lawyer at Morrows. Hi Kiren, how are you?
Yeah, I'm good, thank you, Brent. How are you going?
Very well, thank you.
Good.
Kiren's going to just have a quick chat to us today about the rules that are changing in the estate planning world, and specifically about powers of attorney and losing capacity.
Yeah.
I think it's a big area for advisors to become familiar with when advising their clients, because there's a lot of pitfalls that I'm sure a lot of us aren't known about. So do you just want to give us a bit of an update as to some of the changes that have happened recently in the powers of attorney legislation?
Sure. So I assume a lot of accountants would be working in this space, so you may already be familiar with the old regime. So 1 September this year, so 1 September 2015, the new Powers of Attorney Act 2014 came into effect. And what that's done is that's changed pretty much how powers of attorney will work from that date onwards. So prior to 1 September 2015, we had 3 different powers and we had 3 different forms. They were under 3 different pieces of legislation. So you had the enduring power of attorney financial, enduring power of attorney medical, and then you had the appointment of the enduring guardian. Now, since 1 September 2015, that has changed. The enduring power of attorney medical has remained, so that is the same as it was under the old system. So it's the same form, same legislation. The financial and the guardian have changed a great deal, and this is where there's a significant change. So in the new system, we've got one form, which is about 4 or 5 times the length of the old form, and that's for the enduring power of attorney, financial and personal. So that term that was used previously for the lifestyle attorney, the guardian, that's now your personal attorney. And the form allows you to make a lot of nominations. So you can nominate how your attorneys are going to behave. So is my attorney going to act for me only for financial matters, or only for personal matters, or is he or she going to act for me for both? Am I going to have one attorney, or am I going to have more than one attorney? If I'm going to have more than one attorney, how are they going to act? Is it going to be joint, i.e. they've got to make decisions together before they can proceed? Is it going to be joint and several? Is it going to be a majority vote? What kind of rights am I going to give to my attorney? So under the new form and in the new legislation, a person giving the power can think about giving extra powers that you wouldn't normally associate with allowing an attorney to have. So for example, I'm going to give my attorney the power to make gifts on my behalf. I'm going to give my attorney the power to enter into a conflict transaction, or I'm going to give my attorney the power to maintain my descendants, or even pay themselves. So a lot of changes, and it's really about protecting the person giving the power and allowing them to have the maximum capacity to take charge of the decisions that they make.
Yeah.
There's one more.
Go for it. No,
probably 2 more. The first is there's something called a supportive attorney now, which is a major change, and that's sort of I'd say an Australian first. So in Victoria, the legislation's changed to allow for somebody to support, say, someone who's elderly, who's thinking, okay, I've still got capacity, but I'm not as healthy as I was, and it's not as easy for me to get around, and although I can decide what I want to do with my finances, I haven't got the energy or the ability or the ease to run off to the bank whenever I want to. So they can nominate a supportive attorney to make or to act for them in terms of support transactions, in terms of collecting information. So more transactional work, it's not related to decision making at all.
Yeah.
So that's sort of another major change.
Yeah, big changes, and I think the purpose of these changes are really to get to the attention of the abuse that's happening in the power of attorney at the moment. I think a statistics which you said earlier was about $57 million was lost just in the state of Victoria for 2013-2014 year, with abuse of these powers of attorney. So that's a massive number, and a lot of them are directed at their elderly people.
Yeah.
Can you just tell us a little bit about that?
Yeah, so this morning I did a presentation just to the group, and I put that statistic in because I think it's really compelling, and I think it really highlights, the need for reform in this particular area. And, you noted the $57 million. If you think about it, that's 1 year, 1 state, and that's the reported cases. So goodness knows how many more there are out there that never sort of hit the books and were never reported. But elder abuse is something now that's really coming to the forefront and is coming to the attention of a lot of people. And there's been papers come out in CPA as well. I've sort of read one fairly recently. It's where you've got vulnerable people in our society, and they might have set up a power of attorney many years ago, and that attorney has started to act, and essentially they cannot recognise a conflict situation. So they're basically acting, making decisions on behalf of the attorney, who by now most likely lost capacity and can't sort of figure things out for themselves, but they're acting to their own benefit. So as an attorney, you have what's called fiduciary obligations, which are your fundamental obligation to stand in the stead of somebody else and make decisions in their best interest, not in your best interest, in their best interest. And if you can't recognise that conflict, you should not be acting as attorney. And that's sort of where the whole elder abuse has, unfortunately become a big topic. So a lot of the legislation is about ensuring that a person giving a power is aware of their rights and aware of how they can manage their lifestyle once they do lose capacity. Also ensuring that an attorney is aware of their obligations. Because sometimes, you have attorneys who say, I'm sorry, I didn't realise this is not what I was meant to do, or, otherwise trying to get out of it. Sometimes, I've had a recent case go through the VCAT, which was an elder abuse case, and the attorney's argument there was she was not acting under power of attorney.
Yeah.
So effectively, she was appointed by her mother many years ago, and recently she started using this power of attorney, I would say, and she's plummeted, I'd say plundered over half of her mum's money on her own. Yeah, on her own lifestyle. She's built up her own property, she's furnished her house, she pays her daughter's vet's bills. It's astonishing.
Yeah.
And her argument was that she wasn't acting under power of attorney, but there is an implied obligation of transparency. There's very, very strong fiduciary obligations acting as power of attorney. And that's really what we want to allude people to. It's about sharing information and knowledge, so that we can all be aware of rights in individuals, so that when the time comes, you don't need to be a vulnerable or exposed person in society. You've got your own rights, and we're out there to help you protect them.
Yeah, that's great. Look, and it does seem quite complex, especially for us. We're accountants and we're not lawyers. What do you think us accountants as CPAs can do with our clients when advising them if we get into a situation? How do we become more aware ourselves about what you're just asking us? But more importantly, how do we get to know more about our clients' affairs so we know we're addressing these things with our clients when we speak to them?
I think part of it is, you would be your client's trusted advisor, I would say. So you look after their accounts. You've been doing it for a number of years. I would hazard a guess that you know more about your clients' affairs than they do. And so I'd say it's probably about, in the first instance, if you're not comfortable with, it is a complex area, and there's a lot to think about. And when we move through powers of attorney and we move into the estate, wills, superannuation, family trusts, corporate structures and the like, it can get a bit overwhelming. So I would say, have a think about each client on a case-by-case basis. The legislation, the changes in the legislation are very much geared towards thinking about everybody as an individual and thinking about their needs. And if you have a think about your client and you think, okay, this is a little bit too much for me, I'm a little bit out of my depth, contact a lawyer that you feel comfortable with. I'm happy and available to talk to anyone who might need. And just have a chat with them. Say, I've got a client, this is sort of their situation. The lawyer will likely work through the scenario with you, and that'll help you feel a bit more empowered to address issues. And as long as you can sort of identify issues and flag issues, then you can sort of, get the client on board, have a conversation with your client, and that might be at, say, a regular meeting that you have anyway, where you look at their superannuation fund deed and say, okay, we're going to review your binding death benefit nomination. You might say at that point, after you've sort of understood the scenario yourself a better, okay, we're looking at your binding death benefit nomination today, but that's only one part of your asset base. What I want to think about today with you is, let's consider your holistic asset base. Let's look at all your assets, and let's look at getting a will together for you. Let's think about powers of attorney, so addressing key points in your life where you might not be able to make decisions, and that's the crunch time. So it's planning ahead. So form the links, have the discussions, and then, don't take the risk on yourself, I'd say, because I'm a lawyer. I wouldn't take the accounting advice piece on because I just don't know enough about it. So I think it's all about information sharing, as I said, and sharing knowledge.
Look, it's very valuable, and it's a very valuable discussion to be having with your clients. So you should be having these type of broader discussions with them. One of the things that hit home for me when you were talking to us today was you said you've got to get the documentation right. The legislation and the documents can actually have a huge impact on people's lives, and what's available out there is, there's templates, and there's, you can sign up to some legal documents for $150 and you can weave your way through a power of attorney. But without the knowledge of a lawyer and a solicitor who's an expert in this area, these simple mistakes can have a huge ramification on the clients down the track. So can you just elaborate on that a little bit?
Yeah, I think that's a really important point. And one question that, lawyers get asked a lot is, should I come to you, or should I just go to the post office and get myself a will kit for, $3 or whatever it is, and I can just draft up my own will? And I mean, I'm a bit biased, but my answer will always be, speak to a lawyer, speak to a specialist always, because at the end of the day, you can fill out a form, but you won't ever know if you've got it wrong. You won't ever know if you've got the legal points covered. And with, for example, will kits, where we see a lot of pitfalls is, mistakes around who's going to be the executor. They appoint somebody who's actually not really up for the role. Mistakes around dealing with their entire estate. So intestacy becomes a major problem. Partial intestacy becomes a major problem, where they sort of go through and tick the boxes and say, okay, up till this point, this is how I want my estate to be dealt with. But then they don't consider, what if these people don't survive? Then simple things like executing, using different pens, or not dating correctly. So there's a lot of technical requirements, there's a lot of legal knowledge, and then a major problem that we as lawyers, are really trained to deal with is, where are the instructions coming from? Is the client giving these voluntarily, and are they really his or her testamentary instructions? Or is there someone talking in their ear? Is there a spouse or a child who's basically saying, this is how we want you to set up your powers of attorney, this is how you need to set up your will, so that basically I can, take the money at some point and do what I wish with it. So is there an element of duress? And also the other thing is capacity. Does your client have the capacity to actually give you the instructions to set up these documents? So a lawyer is trained to look very closely at how a client's instructions are given, and that includes looking at their body language, their tone, who else is involved with them, their family situation, and today we've got a lot of blended families, so considering everything. And obviously then making sure that the documents cover off their whole estate and everything is dealt with, so there's no intestacy issues. If there's powers of attorney that we're looking at, ensure that the people that they're appointing are correct and appropriate. So appropriate means, the person who's going to stand and make the best decisions for that person, and people who understand the responsibilities involved. So I think, you can get them cheaply done, but it's best to go to a specialist.
Yeah, and the impact is just huge, isn't it? I mean, if the client's relying on you to look after their affairs and something goes wrong down the track, the ramifications are just huge. So I think the message is clear, really. This is a real issue, and I think we should really start to understand it a little bit better. Don't put your head in the sand.
No.
And don't try to do it yourself. Speak to a specialist, speak to a lawyer who specialises in estate planning, because you don't have to be an elderly person to go through incapacity issues or anything like that. It can be any age, it can happen to anyone. And these are real issues dealing with every single person. So you as the advisor have got an obligation to ask these questions and help your client out.
That's right. I mean, you could you could leave this building, get hit by a car and lose capacity.
Touch wood.
But the point is, when things go wrong, if you're the trusted advisor, the client's likely, or the client's family, the client's angry family, is likely to come back at you and say, well, hang on, you should have had a conversation with me, shouldn't you? Because you're the one that Dad goes to for all pieces of advice. You're the one who manages pretty much my dad's life. You know everything about you know more about his affairs than I do. And so, get on the front foot look at each client case by case and just say, okay, what do I feel comfortable talking directly? Where do I need a bit of help? If you need a bit of help, reach out for a lawyer, have the conversation, and then, get it moving. But do it while your clients, have lots of time and they've got capacity, so they can also think about it. There's a lot to think about, so they might need a couple of meetings just to go through, understand all the issues. And, these are just powers of attorney, but if you're looking at the whole estate plan, then we're really looking at their wills, we're looking at their superannuation deeds, we're looking at their binding death benefit nominations, their family trust, their corporate structures, and of course the powers of attorney. There's a huge amount to take into consideration. So give your clients time to get their head around it, few meetings. Doesn't matter if you sort of redraft documents, as long as it's what they want and what's going to work for them.
Yeah, so Kiren, thank you for your time. Again, strongly advise to get on the front foot with this because it's a minefield later on. We don't want to be going through VCAT and estate litigations and things like that.
No.
It really is a minefield. So get on the front foot and speak to your advisors and really start to tackle this issue front on.
Yeah.
Thank you for your time.
Thank you very much for having me.
Thank you.
Thank you.